defence line was presented yesterday. The furthest alternative that I'm going to present today only applies in the hypothesis that the Honourable Pre-Trial Chamber 2 considers that, despite what was shown yesterday, that the Office of the Prosecutor has demonstrated proof that there are reasonable grounds to believe that Mr. Abdul Rahman could be responsible for all or some of the crimes in the document containing the charges. So it is therefore within this hypothesis that I'm going to present my submissions this morning. Of course, this hypothesis implies no admission of that hypothesis, but I would also like to offer the most complete defence possible. Just by way of reminder, to go back into the discussion for this morning, with regards to the identity of Mr. Abdul Rahman, his civil status, so born in 49, 1st of January, according to the estimation, the official estimation, OTP 02160777. He is from Riyadh al-Bardi. He is from the Taisha tribe. I'm sorry, the link was 02160777. Thank you. So we heard that he had medical training. He was registered with the Auxiliary Medical Professions Council in 1984. That's DAR 0010005. And he also joined the Central Police Reserves on the 28th of July 2005 with the grade or title of new recruit. I used the word blue, realizing afterwards that this word was used by the distinguished legal representative of victims, Madame Clooney, with a complete other meaning. So the rookies, this is quite the word used in the context of my presentation yesterday, meant that this was a new recruit into the ranks of the police. He obtained a certificate in pharmaceuticals in 2012, and his salary for January 2020 as a warrant officer was 660 Sudanese pounds, DAR 3100020006. So I would also like to remind everyone about some of the questions to which there was no answer on the part of the prosecutor, which I mentioned yesterday. And in particular, who is Mr. Abdul Rahman or Ali Koushib? Who was that person before the event of 2003-2004? And I repeat what I said, there's no information with regards to the origin of his authority of power of Ali Koushib, but before 2003, he left the army at the start of the 1990s with the grade of warrant officer. Several witnesses describe him as a soldier. DAR OTP 0215 9919 on page 9935 thereof, or witness P117 in the document DAR OTP 0128 0042, page 71 thereof. And I would like to just stop making a reminder mentioning the CV of Ali Koushib, which was shown yesterday on the screen, which told us that he joined the army in 1965 and that he worked in the medical corps. And on that basis, and that's the real point of departure of my presentation this morning, we have no information, no start of evidence that either Mr. Abdul Haman or Ali Koshieb, or both of them, followed the slightest military training or any training or awareness raising with respect to international humanitarian law. International or international law of armed conflicts, these are synonyms in my presentation, or either any awareness raising in the principles of the distinction between combatants and non-combatants. So within the framework of the preparation of his defense, the defense obtained or tried to obtain the report of an expert in law of armed conflict. I'm going to present it very briefly, and this was written by Madame Linda Streit-Murnane, who is a colonel in the armed forces of the United States and who spent a long career as a jurist in the army of her country. She was also employed by the International Criminal Tribunal for the former Yugoslavia as a jurist for the chambers, and during certain months she was exercising the function of a deputy registrar of the former Yugoslavia Tribunal, and she also worked as the chief of the court management service of the Yugoslavia Tribunal and the Lebanon Tribunal. I think I have made no mistake there. Now, the expert report which we asked for from Madame Murnane was about 6 different questions which were put by the defense, and they were put into the report. I will give the number DAR D31 0005 0001. So there were 6 questions that were put in the report. Here I would have to state that Madame Murnane was not familiar with the case, Abdul Haman, and that for the needs of her expert report, the defense didn't consider it to be useful to share with her the document containing the charges or other information related thereto. All that was asked of her was to answer as best as she could the 6 questions that were put to her. And I would start by quoting one of the excerpts from her report, which is on page 0005, which is very interesting information, but it wasn't asked for, but it speaks about the Sudan. Madame Murnane refers to a study of the United States Institute of Peace, USIP, under the signature of Blank and Noon, Law of War Training, Resources for Military and Civilian Leaders. This dates from March 2008, and she refers to page 8 of the said report, and she states that in the USIP study, The authors incorporate a directory of law of war training programs.
They report that domestic law in Sudan includes a military order issued by the Army Chief of Staff to conduct such training, but the report notes that there is no designated unit responsible for carrying out the training. The report further indicates that the Sudanese rely upon self-generated training materials. Recipients of the training are listed as being junior officers and non-commissioned officers.
This passage from the report therefore informs us that in the Sudan there is not a real training in law of armed conflict which is available for soldiers. I will come back to the report by Madame Murnane, and I'm now going to mention the law of interest to us, namely the law of the court. So according to the law of the court concerning the mental element common to all the crimes of the court under Article 5, which is the knowledge. Article 31 of the statute, entitled Mental Element, provides that unless otherwise provided, a person shall be criminally responsible and liable for punishment for a crime within the jurisdiction of the court only if the material elements are committed with intent and knowledge. That is the word knowledge that is of interest to us. Article 33 continues, for the purposes of this article, knowledge means awareness that a circumstance exists or a consequence will occur in the ordinary course of events. Know and knowingly shall be construed accordingly. I would ask the Honourable Chamber to retain for my demonstration the word knowledge when a person is aware that a circumstance exists, because that is what I would like to use for my demonstration. Now, Article 32(1) of the statute, entitled Mistake of Fact or Mistake of Law, states that a mistake of fact shall be a ground for excluding criminal responsibility only if it negates the mental element required by the crime. Article 32(2) states a mistake of law as to whether a particular type of conduct is a crime within the jurisdiction of the court shall not be a ground for excluding criminal responsibility. A mistake of law may, however, be a ground for excluding criminal responsibility if it negates the mental element required by such a crime. Article 33, Superior Orders and Prescriptions of Law, states the fact that a crime within the jurisdiction of the court has been committed by a person pursuant to an order of a government and or of a superior, whether military or civilian, shall not relieve that person of criminal responsibility unless that person was under a legal obligation to obey orders of the government or the superior in question. B, the person did not know that the order was unlawful, and C, the order was not manifestly unlawful. And finally, Article 33(2), for the purposes of this article, orders to commit genocide or crimes against humanity are manifestly unlawful. A last text that I'm going to read from the court. Well, not exactly. I'm going on to the elements of crimes now. The general introduction, paragraph 2, states, as stated in Article 30, unless otherwise provided, a person shall be criminally responsible and liable for punishment for a crime within the jurisdiction of the court, only if the material elements are committed with intent and knowledge. where no reference is made in the elements of crimes to a mental element for any particular conduct, consequence, or circumstance listed, it is understood that the relevant mental element, that's to say, intent, knowledge, or both, set out in Article 30 applies. Exceptions to Article 30, based on the statute, including applicable law under its relevant provisions, are indicated below. What I would propose to retain from these texts are the following. In the light of these texts, the Office of the Prosecutor, and who has the burden of proof with regards to the crimes, must demonstrate the knowledge of the perpetrator at the time of the acts. And what are the circumstances? This is that there's a circumstance which exists under Article 30, paragraph 3. In a case of errors with regards to the facts of the existence of such a circumstance, there's exoneration from criminal responsibility under Article 32.1 if the mental element of the crime disappears, and in case of error of law on the existence of such circumstance, there is exoneration from criminal responsibility under Article 32.2 if the mental element of the crime no longer disappears, or if it goes into the illegal nature of the order received under Article 33.1, unless it is an order to commit genocide or a crime against humanity. I'm going into more details now with regards to the particular circumstances which are required in the case of a crime against humanity. In the elements of crimes, Article 7, paragraph 2, tells us that the last two elements for each crime against humanity describe the context in which the conduct must take place. These elements clarify the requisite participation in and knowledge of a widespread or systematic attack against a civilian population. However, the last element, I just have to have a drink. The last element should not be interpreted as requiring proof that the perpetrator had knowledge of all characteristics of the attack or the precise details of the plan or policy of the state or organization. And the relevant exceptions from the elements of crimes relevant to the crimes against humanity which figure in the document containing the charges. These are the sections 71A3, 71D5, 71F5, 71G1, 4, 71H6, and 71F5 of the elements of crimes. They require that the perpetrator knew that the behavior, that the conduct was part of a widespread or systematic attack against a civilian population or intended it to be part thereof. And what I would propose that you take from this text is that the existence of a widespread and systematic attack against a civilian population was a circumstance so the perpetrator has to be aware of that under Article 33, paragraph 3 of the statute with regards to crimes against humanity. The fact that the person referred to in crimes against humanity was part of the civilian population, and one of the circumstances is to demonstrate this knowledge under Article 30, paragraph 3 of the statute. In the case of errors with regards to the existence of such circumstances, there is exoneration from criminal responsibility under Article 32.1 if the psychological element of the crime against humanity disappears. In the case of error of law with regards to these circumstances, there is exoneration from criminal responsibility under Article 32(2) of the statute if the mental element of the crime against humanity disappears. And finally, there's hierarchical superior orders under 33 does not occur in crimes against humanity. I now go on to the knowledge in the case of war crimes. The element of crimes 8 states that where it concerns the two last elements of each crime, it is not necessary to establish that the perpetrator determined at a legal level the existence of an armed conflict or the international or non-international character of the conflict. And in this regard, it's not necessary to establish that the perpetrator had knowledge of the facts establishing the international or non-international nature of the conflict. It is only necessary that the perpetrator had knowledge of the circumstances establishing the existence of an armed conflict, which is implicit in the terms in the context of or associated with. Where it concerns the war crimes or attacks against a civilian population, which is in the document containing the charge number 1, the section 8, 2 and 3, E2, E13, you have to prove that the perpetrator intended the civilian population as such to be the object of the attack, or civilians not taking directly part in the hostilities. Where it concerns the charges, pillaging, charge 9, rape, the elements of crimes, sections 8, 2, E1, 2, E2, E5, and 8, 2, E6, 1, 4, Roman 6, of the elements of crimes requires that the perpetrator was aware of the factual circumstances that establish the existence of an armed conflict. With regards to the destruction of property without military necessity, section 8.2e4, the elements of crimes indicates that the perpetrator was aware of the factual circumstances that established the status of this property. And finally, for all the other charges for war crimes pleaded in the document containing the charges, you have the requirement that the perpetrator was aware of factual circumstances that established this status being the status of person hors de combat, so civilians or members of medical or religious staff not taking actively part in the hostilities. So having the status of protected persons under international humanitarian law.
Premièrement, la détermination sur le plan juridique de l'existence d'un conflit.
What I suggest you note from these texts is that the question of an armed conflict, international or non-international, is not one that is relevant here. This is not something that has to be established by the prosecutor that there was an international or not an international conflict. I will not insist on this. However, the knowledge of the circumstances of fact establishing the statute of victims as persons protected by international humanitarian law has to be established in virtue of Article 33 of the statute. With regard to the attack against the civilian population, the knowledge of circumstances of fact establishing the statute of the group of victims as a civilian population or civilians not taking part directly in hostilities does have to be proved in virtue of Article 33 of a statute. In the case of mistake of fact on the existence of this circumstance, there is exoneration of criminal responsibility under Article 32(1) if the mental element of the war crime disappears. In the event of a mistake of law on the existence of this circumstance, there is exoneration of the criminal responsibility under Article 32(2) if the mental element of the war crime disappears, or if this mistake relates to the illegal character of the hierarchical order or law under Article 33(1)(b) of the statute. This brings I have now finished with text from the court, and I now move to the subject of national law of Sudan. I will start with the Sudanese Penal Code, which is in the filings under DAR OTP 00210296. This is the Criminal Act of 1991. And I sentenced to death or some other penalty, A, desertion in the face of the enemy, and now I move to C, any refusal to obey orders or any behavior deliberately intended to imperil any headquarters, unit, position, or military property. And now moving to G, committing or failing to commit some action with the deliberate intention thereby of imperiling the success of any force, supporting forces, or part thereof. And now if we could return to Article 50 once more. I did not earlier read Article D, so penalty of death or lesser punishment for any person subject to the provisions of this Act who commits any of the following actions intentionally in the face of the enemy, sorry, it wasn't D. I want to read it. It's A, says the speaker. So, desertion in the face of the enemy. C, any refusal to obey orders or any behavior deliberately intended to imperil any headquarters, unit, position, or military property. And then G, committing or failing to commit some action with the deliberate intention thereby of imperiling the success of any force, supporting forces, or parts thereof. So that took me back to 48. I do apologise. It's slightly muddled here. I had already read 48 to you, and now I want to read a D, paragraph D of 50. So any person subject to the provisions of this Act, whether military or civilian, who commit any of the following actions. D, impeding or seeking to obstruct any victory, advance, deployment, or resupply of the forces. And then one last text that I'd like to bring to your attention from these codes, because a number of these articles are subject to the People of Forces Act, state that they can apply to military or civilian personnel. So it now says the People's Armed Forces Act applies to any person appointed or enlisted under the provisions of this Act, which means under Article 50, where we read whether military or civilian, F, any forces constituted under any given Act or regulation, where such an Act or regulation subjects to the provisions of this Act, and I, all civilian personnel working with the Ministry of Defence or with the services during field service who belong to or accompany the above or any part thereof. So, in summary, under Sudanese law, resisting an order of the law or a competent public servant in detention, arrest, of punishment of a person under the Penal Code is, or the Armed Forces Act is an infraction. And if the person, civilian or military, is subject to the 1986 Armed Forces Act, then the punishment is nothing less than capital punishment. We can now take this down from the screen. I've finished with the Sudanese national law, and I now return to the court, not to its text, but to its case law. The defence of Mr. Abdel Rahman is not the first to rely on Article 33 knowledge. The defence of Thomas Lubanga also followed this path during the confirmation of charges. And I would like to welcome at this point Catherine Mabille, my learned colleague who is listening to us. In the Lubanga case, for the confirmation of charges, the Honourable Preliminary Chamber 1 took an argument presented by the defence saying that the accused could not know that enrolling child soldiers and using them in the forces was illegal and engaged his criminal responsibility. This was based on Congolese law, so an articulation of the principle of legality and an error of law under 32(2) the statute. In the absence of incrimination, the accused could not know that the recruitment of child soldiers constituted a crime. The argument presented by the Lubanga defence is different from the one I present to you today. I am not talking about the absence of incrimination under crimes of war, crimes against humanity. I will not come to that point, but our argument is based on paragraph 33. So I would say furthermore that Sudan is not a state party. The conclusion of a preliminary chamber 1 in paragraph 37 of the Lubanga decision against, according to which DRC was a state party to the statute, does not therefore apply in the case of Sudan. The definition of crimes against humanity and war crimes under Article 7 and 8 does not figure in the Sudanese Penal Code applicable at the time of the facts. And in the Lubanga decision, paragraph 316 said, in consequence, given that there is recourse to Article 33 of the statute, the excuse of the error in law cannot be admitted under Article 32 of the statute only if Thomas Lubanga was unaware of the existence of a normative, objective element of the crime because he did not have any awareness of its current significance, social significance. However, the elements of proof admitted to the hearing of the confirmation charges did not indicate that Thomas Lubanga could have committed an error of this type in the context of the commission of these crimes. So, in difference to that, in this case, the elements of proof being submitted are that Mr. Abdi al-Rahman could not have had the level of proof necessary for this Article 33, given the concerning the statute of protected persons. And if supposing, without admitting in any way, that he did commit all the acts alleged by the OTP, Mr. al-Rahman would have acted under the order of the law, the representatives of the government and or military authorities in the sense of Article 33(1). So what is the proof that I'm referring to in this case? As stated earlier, knowledge whose existence has to be proved, and the knowledge of the status of civilian population for crimes against humanity, and the knowledge of the circumstances of fact establishing the statute of victims as protected persons by international humanitarian law for war crimes. So, Mr. Ali Mohammed, Ali Abdurrahman, or Ali Koshib, did he have this knowledge at the time of the facts? And any reply to this question has to take account of the absence of proof reported by the OTP of the fact that either of these two persons had had any military training or training on law of armed conflicts, or on the distinction between competence and non-competence during the facts. In the filings of the OTP, the PCB, the question of knowledge is covered on two occasions in paragraph 156 of the brief. It states simply, under charge 2, murder as part of crimes against humanity in Bidisi, the perpetrators of the killings were aware of the factual circumstances that established their status. This is a statement, but not any sort of proof. We simply have a footnote which refers to the appeals chamber 3 in Bemba case. It refers to the chamber in a Bemba case. Okay, but this is not a matter of proof. The second reference in the brief is at paragraph 168, where, in relation to charge 3, murder as a war crime in Midisi and Kadum, the OTP refers to a footnote at the bottom of page 563, citing the judgment in the Katanga case, which is ICC 010401073436, and paragraph 784 thereof, which confirms the speaker says he has realised he is going rather fast and will now endeavour to speak more slowly. This confirms the need to prove the awareness of the status of the victims as a civilian population, Article 7, or non-competence, Article 8. But there again, there is a reference to the obligation to furnish the proof, but no proof at all is furnished. Conversely, the memorandum of the prosecution, excuse me.
Yes, Mr. Nichols.
Sorry, again, sorry to interrupt, no objection. The paragraph being discussed is not in the transcript and I didn't hear it, so if I could just have the paragraph where we are again.
Yeah, sure.
Le paragraphe de la décision.
The paragraph from the decision in Katanga was 784. Or the paragraph from the brief. Which paragraph did you need?
168.
168.
Donc je disais que le mémoire.
So, this brief says on a number of occasions, and we heard it 2 days ago and yesterday, that victims of the crimes in the document covering the charges were mentioned as rebels or persons supporting rebels, so persons who under Sudanese law were subject to capital punishment. The OTP kindly allowed us to use 3 of its pages taken from the presentation on the persecution. This is now on the screen. We will go through these quite swiftly, but you can see here that the motive for why these people were targeted, that they were correctly or incorrectly seen as rebels. Treat any fur village as a rebel village, it states here. 4 males arrested on suspicion of being rebels. Most of the prisoners in the police station were 4. So the word rebel is a recurring theme here, and the victims were targeted on the basis of the information to which we attached no credibility, but information that they were apparently rebels or supported rebels. So if I can now move to the next slide.
Men are targeted because it's the idea that the men are allegedly rebels, or they participated more actively in the acts of rebellion. And finally, the last one, political grounds supporting the rebellion. So all 3 grounds of persecution pleaded by the prosecution. Beyond that, all the crimes are committed, according to the Office of the Prosecutor, within the idea that the persons who are targeted are rebels, or they support them. That is to say, under Sudanese criminal law, that is punishable by the death penalty. And once again, I would like to clarify in particular for the community of victims who could be listening to us, that the defense is not questioning the idea that these victims were victims, but as the Office of the Prosecutor said, they were described as rebels. And I go back to the report of the Colonel Linda, the document DAR D3100050001, and I'm going to read certain relevant passages therefrom. And on page 0004, it is written by Madame Menem.
Formation en droit des conflits armés.
Training in the law of armed conflict.
Will intuitively be familiar with the national obligations under the Geneva Conventions in terms of the required behavior of military members and civilians in conflict situations. À la page 5.
On page 5.
Is a particularly challenging concept which requires careful training in the context of non-traditional combat. Citant un auteur,
Quoting an author, Madame Menem writes,
civilian and fighter of military objective and protected object make application of the principles of distinction and proportionality very difficult. New warfare's complexities confound the classic bifurcation between combatants and civilians in the law of armed conflict, a distinct asymmetry between the military and hostile persons predominate in new warfare. No, j'ai sauté ligne.
No, I missed a line here.
between the military and technological capabilities of the state and non-state parties and the intermingling of civilians and hostile persons predominate in new warfare. Both challenge the effective application of the law of armed conflict. First, the disadvantaged party has an incentive to blur the distinction between its forces and the civilian population in the hope that this will deter the other side from attack.
So it wasn't just adult men among the victims. According to the description made by the Office of the Prosecutor, there were also women, there were children, and there were the elderly as well. Now the question was put to Colonel Mannain, who replies as follows.
Particularly in the circumstances where one is untrained and engaged in non-international tribal conflict or insurgency, the clarity of the existing principles would be limited. Citant,
quoting an author,
which encompasses the person identified in the list, inclusive in 1 through 4, c'était homme adulte,
adult males, children, elderly,
to those persons who retain immunity from attack at all times. Persons who engage in hostilities, however, are legitimate targets and are not protected under the Geneva Convention. In the absence of training and in the context of an insurgency or tribal warfare, these categories of protected person can be difficult to discern. Where a variety of persons who are neither soldiers nor members of armed groups play a continuous role in the hostilities, the level of direct participation arguably makes them legitimate targets at all times. The distinction is further blurred when you consider the ongoing discussion about the concept of self-defense, complicated by current dialogue among IHL scholars with respect to hostile acts and hostile intent.
Page 7.
Where a person was placed in a situation where irregular or rebel forces are mixed in with the general population, the challenges posed in proper application of the principle of distinction would be particularly difficult for the reasons cited above.
What you have to remember from that, from Colonel Mannain's report, is that the intuitive understanding of the principle of a distinction between combatants and non-combatants cannot be presumed, particularly in the absence of specific training in the implementation of this principle of distinction. This understanding is all the more difficult and therefore improbable in the context of an armed conflict was not international, in which the distinction between combatants and non-combatants is not clear. This applies without distinction to all categories of persons, unfortunately, including women, children, and the elderly. There are examples in the report of Colonel Mannain's report here, which I shan't quote here, but the use of children in the armed conflict is done in certain conflicts. And this knowledge of these, where, for example, the use of children as human bombs is something that happens in certain conflicts. The totality of the evidence which is relevant and available in this case goes in the sense of a lack of knowledge, a lack of understanding of the distinction between combatants and non-combatants. We have the proof in the case file that Mr. Haman only got to the level of warrant officer, and he left the army at the beginning of the 90s to become a chemist. I therefore don't have to repeat the references. I mentioned them yesterday. We have the proof that the training in international humanitarian law was inexistent in the Sudanese army. You have Colonel Manam's report on page 5, referring to the study of the United States Institute of Peace. We have in the case file the demonstration of the existence of a state policy on the part of the government of Sudan. These are in paragraphs 23 to 47 of the pre-trial brief. And according to this state policy, according to the OTP, the logic of it was to assimilate the entire non-Arab population with the rebels and to repress them in the name of the and to repress them due to the counter-insurrection. So to target villages and civilians that were perceived as being associated with or supporting the rebel armed groups. This is in paragraph 24. In paragraph 131, Harun authorized Mr. Abdelrahman to treat any Four village as a rebel village. Paragraph 132, since the children of the Four had become rebels, you can attack. Paragraph 133, the Commissioner of Mukja, Torshain, informing the attendees on behalf of the government of Sudan that if the rebels did not return to the mountains, the Janjaweed had the power to destroy the area because the children of the Four had become rebels. Paragraph 135. Predominantly Fur villages attacked and therefore assumed to harbour supporters of the rebel armed groups.
Cette perception.
This perception at the time, deliberately used by the Sudanese authorities to push some of the population against another part of the population, was furthermore fed by the number and frequency of attacks in the region. We have in the case file the document DAR OTP 01530686, which is entitled Acts or Rebel Aggression against the Towns, Villages and Camps of Darfur. And it goes from the 7th of January 2002 to the 3rd of November 2004. And just in this period, the report, 37 pages thereof, lists 364 rebel attacks, which are listed in Darfur during this period, which averages out at approximately one attack every 2 days. Mukja. So attack number 34 in this document, 23rd of April 2003, 7 Arabs injured, several animals killed, so 3,000 livestock stolen. Attack 40, 30th of May 2003, a person tortured to death and 119 heads of livestock stolen. Attack 53, 2nd of July 2003, police officer Mukja attacked, arms stolen, the shop and the armory was burned. 108, 29th of November 2003, attack on the camps Kaskaldou. 5 Arabs killed and 150 camels were stolen in Bindisi. attack number 36 on the 9th of May 2003. 7 people were attacked on the road from Brindisi to Korbaranda. Horses, livestock and camels were stolen, etc., etc. This perception made the local population look the accomplice of the rebels. This was reinforced by the provisions of Sudanese law, which I quoted, which make rebels all those who support them and or who provide them with support or money or food or any other support, and those who communicate information with a view to assisting their military operations. It makes them criminals who are subject to the death penalty. The exercise of the distinction between rebels and the civilian population for under Article 7 between combatants and non-combatants for the purposes of Article 8 was therefore particularly difficult due to the overall context of prolonged armed violence and the provisions of Sudanese law and the state policy described by the Office of the Prosecutor, consisting of using part of the population against another in the counter-insurrection or counterinsurgency. Another factor which is notable with regards to the complexity is that other dispositions incriminate the resistance to law, which, when the Code of Criminal Justice applies, and this is the case in the counter-insurrection, there is the death penalty for those who refuse to obey it. So, if we suppose that, without admitting anything, that Mr. Abdul Rahman was in a position to decide to obey or to disobey the order that was given to him by Arun Toshain, anyone else, any other civilian or military authority speaking on behalf of the Sudanese government under the circumstances in the case in point and due to
Yes, please.
Apologies, Your Honor. The connection with the English channel has been lost.
Yeah, we know. We're trying to understand whether they can follow anyway or simply we don't see them.
Right, thank
we
you.
do know. We're checking. Mr. Lucia, just wait a second for the court officer to check what's happening.
Your Honours, we will need to re-establish the connection, but it's unclear how long this will take. We beg your indulgence, perhaps 1 or 2 minutes. Thank you.
Well, what I would do, I would allow the technicians to do their job. We adjourn the hearing now, reconvene at 11:20 in half an hour. And meanwhile, yes.
Juste une question.
Just a question. According to your calculations, how much time is left?
Minutes remaining.
Ce sera plus que suffisant.
That will be more than sufficient.
For half an hour, 11:20 sharp, we start. Thank you very much.
All rise. Veuillez vous lever.